Hello and welcome to a fresh episode of Legal Wrangle. In today's episode, we will highlight various developments that have taken place in the field of GST. In this regard, we will be presenting various decisions of the High Courts. Let's proceed to our first case. The petitioner company is engaged in manufacturing and distributing surgical dressing items. It supplied such items to one Gujarat Medical Supplies Corporation Limited, that is GMSCL, which is a procuring agent for the state of Gujarat and supplies them to various hospitals. The corporation invited tenders where the petitioner was directed to separately provide pre-packing rates excluding VAT and GST as well as the rates of such taxes, if applicable. The petitioner claimed that GMSCL incurred the VAT and GST liability, although the same were recovered by the petitioner and deposited them on behalf of GMSCL.
Upon rolling out of GST, the petitioners informed GMSCL that GST at 12% was applicable on the products supplied by it. It also requested that GMSCL make requisite changes or accommodate the new rates. However, GMSCL later responded by stating that the state government was not amenable to revising the rates and that it was decided that the goods would be procured as per rate contract. Besides, GMSCL stated that it would float fresh tender if the supplier of the goods did not accept such terms. This led the petitioner to file the present writ.
The High Court held that mere abolishment of VAT and its substitution with GST would not allow the petitioner to revise the contract rates. The court noted that the petitioners would have to pay the same price quoted by them. It also observed that its intervention would result in varying the terms and conditions of the rate contract, which is impermissible as per Article 226 of the Constitution. It concluded that the decision of GMSCL to not permit rate revision was taken under considering the opinion of the State Finance Department and so could not be said to perverse or arbitrary. Thus, the High Court dismissed the writ petitions. Let us move to our next case. The petitioner company was served show cause notice during the relevant assessment year, raising duty demand under Section 73 of the Finance Act 1994. It then approached the writ court contesting such notice, claiming that the provision of service tax had been subsumed by the GST. Thus, it submitted that the show cause notice lacked jurisdiction.
The High Court directed that notices be issued to the respondents in this regard. It also directed stay on any further proceedings arising from the show cause notice. Let us proceed to our third case.
This case also pertains to service tax matter but viewed in the present era of GST. The petitioner was issued with a notice and subsequent reminders proposing to conduct audit of their records under the provision of Finance Act 1994. The petitioner contested such proceedings on grounds that this act was repealed and that an audit contemplated under Chapter 5 of the Finance Act 1994 could not be saved under Section 174 of the CGST Act.
The High Court observed that the provisions of Chapter 5 of the Finance Act 1994 were omitted by Section 173 of the Act, save otherwise provided under the CGST Act. Hence, if any provision of the CGST Act 2017 allowed the application of Chapter 5 of the Finance Act, then such provision would continue to be in effect regardless of Chapter 5 of the Finance Act 1994 getting repealed.
The writ court also noted that from a prima facie reading of sections 173 and 174, it appeared that an inquiry or investigation is permitted despite the enactment of CGST Act 2017. Hence, it held that the revenue could be permitted to conduct audit proceedings since the period in question pertained to when the Finance Act 1994 was applicable. Thus, the High Court refused the grant interim stay on the audit proceedings and directed the matter to be listed for hearing in March 2019. Let us proceed to our next case.
The present writ was filed by the petitioner contesting levy of GST on the 1% tax collected at source from purchasers of cars priced at above Rs 10 lakhs. Such TCS is levied under Section 206C of the Income Tax Act 1962. The petitioner claimed that such TCS could not be treated as an integral part of the value of goods and services supplied. It was also claimed that the petitioner acted as a mere agent for the state to collect income tax of that the TCS amount is eventually available to the vehicle purchaser as credit.
The High Court noted that the apex court in Dilip Kumar and Company has held that an ambiguity in the taxing provision had to be resolved in favor of the state. Nonetheless, in the present context, to conclude either way, it needed further and deeper adjudication that since the petitioner had raised a prima facie issue which needed the court's attention, the revenue was directed not to act as per clarification given in serial number 5 of CBIC circular number 76/50 of 2018 GST pending disposal in the present petition. The court also clarified that the outcome of the petition would not prejudice the revenue's right to collect such tax in future if the writ outcomes is adverse to the petitioner. Let us now proceed to our last case.
The petitioner was served 2 show cause notices in December 2018 and immediately thereafter their bank accounts were provisionally attached for recovery of taxes of more than Rs 3 crores. Hence, the petitioner approached the writ court seeking that such attachment be lifted.
The High Court observed that the petitioner was not a fly-by-night operator and that it had paid taxes of above Rs 100 crores in the previous year. Hence, it was necessary for the revenue to explain the expediency and rationale behind ordering such attachment of bank accounts which had virtually crippled the petitioner's business operations. Hence, the revenue was directed to lift the attachment over the bank accounts conditional upon the petitioner maintaining balance of Rs 4 crores in one of them. Notices were directed to be issued. This brings us to the end of today's episode of Legal Wrangle. Please stay tuned to TIOL Tube for our upcoming videos. Please also feel free to share your views with us at editor@tiol.in. Thank you for watching. Have a good day.